when you leave work at 4:30, you're racing to law school, you get there after 5, you're trying to put something to, a quick dinner to start classes at 6 o'clock. Classes are over at 10 o'clock. Now you're all wired because the last professor has called you. By the time I got home about almost 11 o'clock, you can't go to sleep. And that's where my insomnia started many, many years ago.
Welcome to The Defense Never Rests with Morgan Akins, your monthly dose of uncommon sense about all things legal and some that are not.
Hi, everyone. Welcome to this episode of The Defense Never Rests. It's been a little bit since we've released a new episode, but we are back, and I'm super excited for today's episode. We are joined by Nigel Shepard today, and he's here to talk about not only his experience, he's been in the industry for so many years, but also how he looks at metrics when assessing claims and just kind of to measure how counsel and the claims are moving along. And just the importance that he sees in metrics. And then he just has so many great stories to share about, his experience throughout the years in claims. So with that, let's bring him in. Good morning, Nigel. Welcome to the Defense Never Rests today. I'm so happy to have you.
Oh, well, thanks for having me. Absolutely looking forward to this.
So, you and I talked not so long ago about coming on the podcast, and I think we have so much to talk about today because you've had so much experience. And then, during our conversation, we were talking a lot about how you value and look at like metrics and the metrics that your outside counsel show you. And that's kind of how you evaluate how cases are going and who you like and who you don't like. So I want to dive into that in a little bit. But before we get there, I want to talk about you. So everyone knows who Nigel is and why we're talking to you and why we should listen to what you have to say. But, you're currently the chief claims officer at Kingston Insurance, but that's not where you started. You're a lawyer by trade, and I get a lot of lawyers on this podcast. It's shocking, I know. But we all have different ways of how we got there, and why we got there. And I'm always so interested to hear about everyone's path because I get such wide range of responses to it. So I'm curious, how did you decide that, you wanted to go to law school? Were your parents lawyers, or were you like me that you just didn't know what else to do? So that's just what you did. So I'm curious how you ended up there.
Yeah, it would be great to say that I wanted to get into the claims industry when I got my first claims adjuster kit for Christmas when I was 6 years old, but that would not be true. I came out as everyone else does. You come out from college and your parents are telling you need to find a job because you won't be living here forever. And so I started looking, and quite frankly, like most people that got into this industry, which is probably one of the problems, I kind of fell into it. I saw an ad. It was with Allstate Insurance Company. So I cut my teeth in the insurance industry with Allstate. And then I moved over to AIG. Then I discovered something called reinsurance, and a company called NACRE hired me. And while there, my boss had taken me out to lunch with all the heads of other reinsurance companies. And I'm about 23 years old. I'm sitting with all these senior people, and I realized that that's the job that I wanted, and that 80% of the people at that table had a law degree. Mm-hmm. So I just drew those two lines together and said, look, if that's the position I want, I need a law degree. So I went to law school at night.
Okay.
And so doing that, I have to admit, I came out obviously with the law degree and I passed the New York bar, but I would honestly say that the thing I really got out of it is when you work full time in the law school at night, at that point, I realized there isn't any challenge you can throw at me after that that I'm going to be, afraid of. And so that was the big walk away from that. And so I came out, I stayed in reinsurance for a while, all domestic. And then I got into international. I moved to London. I was a global head of claims for two different companies. Came back to the States, worked for New York Fair Plan for a while. And then I got into high net worth claims with another company. And then about a year and a half ago, I joined Kingston Insurance Company as a chief claims officer and senior vice president. So I've had experience in both domestic, international, direct insurance, and in reinsurance.
Yeah. Well, so back to when you were going to law school at night, how is that experience for you? Because I imagine it was like you had two jobs, like when I went to law school, I took it seriously, but it was still like kind of an extension of college, like that was the mentality of a lot of people around me. But when you go at night, you're not there for really fun. Like you are there to get stuff done.
Exactly. But I would say that because you have such limited time because you have a full-time job, I felt like I maximized my time much better.
Mhm.
And I would honestly say, I'm not sure I would have done any better had I gone to law school full time. It would have been easier on me, but I don't think I would have used the time or maximized my time the way that I did. But when you leave work at 4:30, you're racing to law school. You get there after 5. You're trying to put something to, a quick dinner to start classes at 6 o'clock. Classes are over at 10 o'clock. Now you're all wired because the last professor has called you. And I was the last person between leaving class and answering that question. So no pressure at all. So you're all kind of wired up. By the time I got home about almost 11 o'clock, you can't go to sleep. And that's where my insomnia started many, many years ago. You're up, you're thinking, and I would say it's a 4-year program, by the way. I would say the first year I would come home, still have to study, until about 2 o'clock in the morning, get up at 6, go to work and start all over again. But I would say that the amount of studying I had to do decreased dramatically as the years progressed.
Yeah. But that's a grind though, too.
Yeah.
I mean, it's a long, long grind because then you never had any downtime for your brain because
Right.
you're overstimulating it, at night through school. Then you have to do your reading for the next day. And then you have to go to a job.
Right.
And it's not like you're going to a job that you're like phoning it in. You also have to use your brain
Right.
at your job.
And it was a job that involved also a lot of traveling. So I spent a lot of time when I'm on the airplane actually reading my law school books as well.
Wow.
So you're right, there was no downtime at all. I'm either in class, at work, at home studying, or on a plane or at the hotel room reading law school books.
And did it kind of fit your personality though? Are you like a go all the time? Or was it just at the time you just had to do it because that's what needed to be done?
Honestly, one of my skill sets is really setting strategy. And this was part of the strategy, as I said. I saw this is what I needed to do to get to my end goal. So I did that. And to be honest, and once I start something, I don't quit. And so I remember sitting in law school for the first day, and I remember saying to myself, well, now you've done it, because now I've started, now I have to finish this. So it wasn't really that much more thought other than the fact that it was what I needed to do to get to where I needed to be.
Yeah. So and at the time you were working at was that when you were at a reinsurance? Okay. Right. So it's funny when I hear reinsurance, there's so much confusion about as to what, or maybe it's my confusion of what reinsurance is, but I remember distinctly at my old law firm, I had a colleague there that was a good friend of mine, like a mentor, and he was leaving and he was going to a reinsurance company. I was like, yeah, like, what is reinsurance? And he's like, I don't know. I just Googled it before my interview.
Same here.
And it worked. He's like, and I got the job. I was like, well, I hope you figure it out when.
Well, that's not like my experience. I was sitting at AIG as a litigation specialist, working on cases for the 5 boroughs of New York for AIG. And I got a phone call, and I'm living in Queens, working in Long Island. I get a phone call about a job in Connecticut. I'm like, Connecticut? But I remember driving there, and it was for reinsurance. I did the same thing. I looked it up, but back then, I just couldn't Google it.
Yeah.
And so I looked it up, and all I saw was reinsurance is the insurance of insurance.
Yep.
And that's all I knew walking into the interview was it was insurance of insurance. Other than that, I couldn't tell you anything else. But I still learned a lot more. The way that I look at it is it's like going to war, right? And so if you're on the direct insurance side, you are the soldiers at the front line, right? Reinsurers, we're the generals way in the back, overseeing what you're doing and trying to place you in the right positions and kind of sending you guidance and things like that.
Yeah. I mean, it's complicated because it's it's like almost like an excess kind of layer in a way. Like it doesn't really see a lot of the litigation, like courtroom action so much as it's like way behind the scenes.
Exactly. And the other thing too is when you're on the direct side, you're looking at that individual file, you're trying to manage that case as best as you can. From the reinsurance, it's really looking at the book of business. So if I'm insuring XYZ insurance company, I'm more concerned about how you are managing all your claims. And so we're looking at it from more of a holistic approach.
Well, and that background though must have really like been a really good groundwork for where you are now, to be able to look at the holistic picture versus like a smaller funnel.
Well, absolutely. And keep in mind too, as a reinsurer, we would go into other insurance companies and do a reinsurance audit or reinsurance claim review. So I got to see how other carriers were managing their claims. And so when I sit back and I talk about, okay, let's put together some best practices. Okay, I could draw on experiences that I've had for companies that I work for, but I can also draw on the vast number of companies that I've audited over the years and kind of pick and choose what I thought worked and what didn't work.
Yeah, absolutely. So what made you, or what was the precipice to move on from that to somewhere else?
Honestly, I mean, from the reinsurance market, or
yes, yeah.
Honestly, I got an opportunity to be the head of global claims for a company and move to London.
Yeah,
but that
I'd take it too.
Both insurance and reinsurance. So that was a great opportunity. I was working 2 blocks away from the Lloyd's.
Yeah.
What I call the grandfather of insurance. So it was just an absolute wonderful experience to be able to sit there, work there, understand that market.
Well, and I hear that. So 2 of my partners, they visited Lloyd's, and like it's just the experience of going to that building. From what I understand, is just it's an experience itself.
It really is, because in a lot of ways, I feel here in the States, we haven't done, when I say we, I'm talking about the insurance industry, we haven't done a great job of branding ourselves, right? And so people always look at us as, I don't want to work for insurance. But it's amazing when you go to London and you're talking about Lloyd's, it's like you really walk in there with a sense of pride because like everyone knows where the Lloyd's is, everyone knows the building, it just kind of stands out. And so it really was seeing insurance from a much different vantage point, if you will.
Yeah, I don't think like Hartford, Connecticut has the same like insurance capital feel as London.
Exactly.
Just not the same. And I grew up in Connecticut. I'm very familiar with Hartford. It's just it's not a draw.
Right. And it's fun because when you're walking down like downtown the financial district, a lot of the brokers, when they want to discuss a claim with you, they'll walk over to your office with the file. So as I'm walking down the street at lunchtime, you will see brokers with claim files like in their arms walking to a client. Now you don't see that if you walk down, Wall Street in New York City. You're not really seeing that.
No. But I also think that the London business market is just so much more like buttoned up, professional. Like it's just a different feel than I think we have here.
Yes. Yeah.
It's like, I don't know, it's like more old school in a way.
It certainly is, because a funny story, a couple of months, because when I interviewed for that job, I actually interviewed in their Bermuda office because they were having a board meeting.
Also not so bad.
And they were all casual, so I assumed they were business casual. So I got rid of all of my suits before moving to London. True story, 2 weeks before I happened to be speaking to who would be my new boss, and I just kind of mentioned, oh, so you're business casual. She goes, oh no, the London office is business attire. So all those suits that I've accumulated all those years I've gotten rid of, now I have to buy an abundance of suits in a very short period of time. So to your point, yeah, it really is a professional look.
Yes.
You couldn't walk into Lloyd's back then, it may have changed now, unless your tie was all the way up, you had a jacket on.
Yeah. I mean, but that's also like, I feel like, we're going way off topic on a business attire, but that is kind of like the London look. It's like that slim fit suit type look, and to go on the hot tube
Yeah.
and sweat. But in any event, so let's move forward though a little bit to what you're doing now at Kingstone. But I also wanted to touch a little bit on, before we get there, on the boroughs, because you mentioned being in the Bronx borough, and I know that's something that Josh is very, very familiar with, the appeal. And I say that in I don't really mean appeal way of the boroughs and what they bring. And I know a lot of your claims now are in the boroughs. So, Josh could probably weigh in a little bit on this too, but it is just a headache to have cases in the boroughs. I mean, it's like its own animal. Like, I deal with Philly a lot, but anytime that I'd have any cases in any of the boroughs, it's like, it's going to cost my client a lot of money, because you'll go, it'll get adjourned for no real reason. Then you'll go back and it'll get adjourned for no real reason. You're there for a calendar call that takes forever. And then your client's like, well, why is this bill so high? Well, because I had to go 4 times and they send a per diem there every time asking for an adjournment. I have to keep going back, and the clerk doesn't listen to me.
Right. You're absolutely right. I guess for me, because when I started way back with AIG, and I was litigation specialist focusing on the 5 boroughs, I was all but 22 going on 23. And so for me, that's how I got my start. So I'm very comfortable in terms of managing cases within the 5 boroughs. The other thing I think about often too is that sometimes we have a certain impression about certain venues, and I'm not always certain if that's a bias that we have because we kind of talk about it and we've had a bad experience here or there. So what we're trying to do is to really see, does the data really support our impression of the 5 boroughs? Because I will tell you, some of my worst verdicts have been like in the Midwest and out in the West Coast. Like, for some reason, I know what to expect in the Bronx and Brooklyn. But I've got hitting really hard in Texas. I've got hitting really hard in Illinois, and then in California with some prior companies. And so I really want to start looking at data to see, is New York City as bad or dangerous as we actually think that it is, or just kind of a built-in bias that we have within ourselves?
Yeah.
I think that, I was gonna say, I think that's a great point, Nigel, because I think people do have this fear almost of the 5 boroughs, but in reality, it's extremely predictable. Like the values may be higher and the verdicts may be more than what we would hope they would be, but they are extremely predictable. The injuries correlate to the values, I think, very well in the Bronx or Brooklyn, all the venues in New York City. So that's one thing that I think can help, look at it from a claims perspective and data is it's very predictable. You're not going to get nuclear verdicts nearly as much as you would in Texas or Florida or some of the Midwest states. So I think that's something that, you touched on that's very, that can help from the claims perspective, is that it is very predictable.
Yeah, I would like, Philly's kind of similar to, you kind of it's a devil that
Right.
and I think the unpredictability about at least Philly is not so much the verdicts, it's more of the rulings that you may or may not see. And then I've seen a similar thing in the boroughs. It's a time suck. So then you end up having the clients end up having to pay more because you have to keep going back because things get pushed. But it's not, at least in my experience in Philly too, it's very like similar in what you're getting. And like when you have discovery motions, it's the unpredictability of the rulings that you may see, or the decision making that you may see, that kind of sets you back, because you sometimes don't see as thoughtful decision making as you may elsewhere.
Nigel, when you're looking at Kingstone's business across, let's just take New York for example, do you look at it from a macro perspective of the state in general? Do you break it down by borough or by the city versus upstate, downstate? How do you typically break down the portfolio and how you assess the risk and managing the claims?
Yeah, we look at it in terms of the 5 boroughs for New York City. Look at it in terms of Long Island as a separate, and then upstate New York is completely different. It might as well be a different country then. But when I try to explain to people, most of our business is written in New York, I always have the caveat that downstate New York, the 5 boroughs of Long Island is completely different than something you'll see in way upstate New York.
Oh, yeah.
And when I say upstate, I'm talking really upstate, like Buffalo and Syracuse, so forth.
Yeah.
A lot of people that think upstate's anything past Westchester County, so I just want to make that distinction. But we definitely look at it that way, because you're right. It's the judges are different, the rules are different, the composition of the potential jury pool is going to be completely different as well. So all those things have to be taken into consideration. When I'm looking to bring on defense counsel, particularly in the 5 boroughs, I really want someone that really understands how the 5 boroughs operate. And that's completely.
So, and when you do that, like, what is it that in particular you're looking for in your outside counsel? Because it has to change, like you said, according to where the case is venued. Because you might want a different kind of approach. You definitely want a different type of approach, say an upstate New York versus the boroughs, or like how we see in Pennsylvania, like the middle of Pennsylvania is totally different from, Philly and Pittsburgh. So, what are some characteristics that you're looking for in your counsel in comparison to those types of jurisdictions?
Yes, I'm always thinking in terms of the end game. So the end game is at some point, if you have to face a jury, right? I try to avoid as much as I can because of unpredictability. But if I have to do that, what counsel do I think is going to do a much better job standing in front of a Bronx jury or a Suffolk County jury? Because I've seen some attorneys, I've said to myself, look, if I had a case upstate or someplace else, I probably wouldn't want this particular person to be representing me. But if I have a case, in the 5 boroughs, I could just see this person attaching themselves to the jury pool and really making good impression and speaking the language and things like that. So it's a lot of different things that kind of play into it. It's just not all about your technical ability to understand the law and things like that. It's about how are you going to present yourself if it ever comes to that point in front of a jury for us.
That's definitely something that I've had or have heard come up before. Someone on this podcast once said to me that they're like, look, I expect all my attorneys to be exceptional. And that's just the baseline. You're all supposed to be good, but it's what you do after that matters. So, you expect everyone to be competent and exceptional, but you're trying to figure out who's going to be the best person for this particular case and this particular venue. Because let's face it, cases are all different too. You might not hire the same person for one case versus the next, because it just
Correct.
there's optics there.
Exactly. You're so right.
One thing that I'm always curious to know from the claims perspective is how the cases are measured, how internally you measure the cases in terms of looking at from how long the claim's been opened, the average close rate, things like that. And I was just wondering if you could maybe speak to how you measure the cases from at Kingstone for the metrics. That always helps defense counsel, so we kind of know what the adjusters are dealing with and what they need to get in and get out the door. And I think that also helps us. So I was just wondering if you could speak to that.
Yeah, some of the metrics to look at. One of the most important metrics is really the cycle time, how long that case has been open. Because the old saying, claims do not age the way wine does. The only good case is a closed case. So I take a look at that, because often what I find is, and I honestly, I put fault on both sides. I put fault on defense counsel as well as claim staff. And when I'm saying this, I'm not talking about Kingstone in general, I'm talking about claims overall. Is that we tend sometimes to get into this routine that we get this case, we've seen it before, and we kind of go through, these steps that we always do. And at some point, I look at the file and I see, I see what you're doing, but why are you doing all this? If the case is ready to settle, just settle the case. You don't have to cross every T and dot every I. Just get that case settled as quickly as possible. So one of the things we have done in Kingstone is we've actually created an early claims resolution team to do just that, is to kind of keep the small claims small. So before someone starts talking to their neighbors and now they're seeing big numbers or getting an attorney or something, get that case settled as quickly as possible. You don't need all the information. If you have enough information, make a settlement, be aggressive about it, and get that case closed. So cycle time is definitely important. The other thing too is how well are we evaluating that case, right? And we're being realistic about it. And we have to realize that claims is really an art form, it's not a science. And so you're not going to get there's no really one right number. And so the difficulty that I see in the industry is how do we define what a win is? You know, what's a win, right? Or did I adequately reserve that case based on the settlement? And so when do I measure that? I could always be adequately reserved a month before I sell the case, right? Because I'm pretty much getting there. But so at what time period? And so what I do is for a liability case, I say, okay, if on average they're open for a year and a half, if they're in litigation, I want to know the measurement against the 6-month mark and the year mark, and then measure that. And then it's also about, okay, this is a settlement. As long as I feel my reserve were like maybe 15% plus or minus from that number, that's how I define an adequate reserve. It's not that, you know, the case settled for 400,000, I was reserved 375,000, so I'm 25,000 under reserve. No, you're never going to get it right. It's about plus or minus, and you have to look at it both ways as well. Being over reserved is as bad as being under reserved. Unfortunately, we don't get treated the same way. Those two things don't get treated the same way. People look at as though if I sell the case below my reserve, I've done a really good thing. And that could be the case. But if you're over reserving your files and then selling them lower, you know, that doesn't help the company as well. So you really have to define what you think an adequate reserve is. And once again, as I said before, it's about that plus or minus percentage-wise above that final settlement number.
It's like taxes. You know, having a big refund is not necessarily always ideal.
Right, exactly. You have somebody else holding on to your money, earning all the interest.
Do you find that the litigations, the adjusters that work, you know, with you and for you, do they typically have struggle over reserving, under reserving? Where is it kind of, you know, is it equal? You know, where do you see that, or how do the adjusters typically handle it? Where do you kind of see the issues there in terms of the reserving? Because I know, you know, people, at least defense counsel, don't understand that when you reserve a file, that money is being spoken for, and the company, you know, has to set that aside. So over reserving, under reserving can be, you know, a big problem for carriers. So I'm just curious as to whether you see more over reserving versus under reserving.
Yeah, and once again, my comments, it's about what I've seen from my experience. Typically what I find, particularly on the liability side, is that oftentimes they're slow to get the reserves up. And what I mean by that is that they want to get all the medicals in and all the information in and then react to that. And here's an example that I often give. It's an auto accident, you're insured, rear-end someone else, that car is a total loss, and the person in that car gets airlifted. I have no medicals, I don't know anything else. Other than the fact, I know it's full liability because that car was legally stopped, we rear-ended it. We totaled the car, so it was a pretty bad impact, and the person was airlifted. Now, I can't tell you if this is a multi-million-dollar case, I'm not sure if the person died or not, but I can tell you that the stat reserve that you're currently sitting at 20,000 is grossly inadequate. And I have seen in my past where people will keep it at 20 until they actually get all the medicals and everything in. I'm like, okay, I don't know what the real number is, but put a significant dollar amount up just based on the circumstances that you have seen and you know at that point. So that's what I typically find, Josh, it's just a slowness to respond to what the potential exposure is. So in that sense, they kind of under reserved at the beginning, too slow to respond to potential exposure.
I was gonna say, and I think that also, you know, the slowness to increase the reserve, I think also goes hand in hand with sometimes, you know, I've seen in my experience, claims struggling to resolve cases early on because they're not making aggressive offers up front. They may offer, on the case you just explained, they may offer $5,000 because they have to tick a box and offer $5,000 and not go after it and try to actually resolve the case, kick it down the can to the litigation teams. And then, then they're kind of, I guess for lack of a better word, stuck with it. So I think that slowness to reserve and also, being aggressive in those initial offers, I think is another thing that I'm seeing that I think would also be very helpful in trying to reserve claims early on. I think that's something that, I've seen, and that's something that, can be helpful.
Exactly. Absolutely right.
Well, I wanted to touch back on what you said about the idea of like having to almost check the boxes. Do you feel as though that sometimes the counsel's like drive to have to like do all the things comes from like a place of inexperience? Like that's when I've seen it. It's like people who like, well, they don't really know how to really think about the case. They'll be like, but I know I should serve discovery and then I should take depositions, rather than like taking a step back and be like, wait, what is my end goal here? And what is the best way to get to my end goal? And do I really need to do all those things? But sometimes I feel like it's an inexperience or lack of confidence in your ability to make the call. So you just go through the steps.
Yeah, I think it's a combination. I mean, I've had attorneys in the past that no matter what case you give to them, one of the first things that they do is they make a motion for summary judgment, right? And I'm like, okay, you're never going to win it on this case. So don't check that box. Don't put the effort in. Don't bill me for this. We're never going to win this. All right. But it's just, to me, it's one of the things that they have to go through in their minds. And so once again, getting back to checking the box. So things like that. To me, it's really the fault of both parties, because what should really happen when a new case comes in, within the first 2 weeks, get together, the claims professional and the attorney, and you start thinking about a strategy. Is this a case that should be settled? Is this a case that we should be trying to try? And that can change over time. But start thinking about a strategy, what you want to do or accomplish to get this case settled at a reasonable dollar as quickly as possible. And oftentimes, because you're not having that conversation up front, everyone is going through their own box checking on both sides.
Yeah. And I think that's so key, is that conversation. Like so you have an agreement, like, what do we want to do here? Like, because sometimes carriers, like, they have a different approach. Like, nope, we want to push till the end and we don't want to show weakness. We don't want to settle. And that might be what they want to do. And so you just have to have the conversation and be like, okay, how do you see this going? Because this is how I see this going. But if that's not in line with that particular carrier's view, then okay, fine. We have to adjust our plan. But you have to have the discussion in order to know you're on the same page.
Oh, exactly. And you're right about that. You kind of reminded me of something. When I worked in the New York Fair Plan, I got there a few months before Superstorm Sandy came and hit. And then after that, there were just a lot of lawsuits, because obviously a lot of companies denying coverage, saying it was flood. And so these law firms that I won't mention the names, but from the South and the Midwest, came to New York, and they're going to make all this money, right? I remember sitting with my president at the time and with the board of directors, and I said, this is what we need to do as a strategy. We're the Fair Plan. We're small. And so these law firms just think they can come here and they're going to try to sue as quickly as possible, do no work, and we're going to write a big check. No, we're going to fight them on every single case. We're going to make them work for this. And guess what? They didn't want to work that hard. So they started backing off, but it was a strategy. But I said to the board that we have to be prepared to spend a lot of money defending these cases. Because we are paying for our reputation within the industry. Because if we lose this time, the next time a big storm happens, those law firms are coming right back at us. So this is where we have to draw, our line in the sand. But that's a strategy that, myself and the board of directors and counsel all got together and discussed. So you really have to have that up front. If that's not your strategy, that's fine, but identify what you're trying to accomplish. and the reason you're trying to accomplish that, and then move forward with that.
But from the viewpoint of outside counsel, like you need to understand the strategy of your carrier. If you want to keep working with them, like you can't just be an independent mind, be like, this is how I'm going to do it. Like this is a business relationship and we're here to help serve the client. So you can't just do your own thing if that's not what they want to do. That's probably not a great strategy to keep them along, to keep them.
Absolutely. You're right. Because some companies, they believe in nuisance value cases, and they're like, they do the economics and say, look, I'd rather just write a check for $5,000 if I owe nothing, because it's going to cost me more to even try to defend this for a couple of months. Some companies say, no, we're not doing that because all we're doing is encouraging people to keep suing us. So you're absolutely right. You have to understand what your carrier is trying to accomplish and then move forward.
And throughout your throughout your career, Nigel, how much have you taken into consideration the reputation that the company you worked for was being perceived, outside the company, specifically with the plaintiffs firms and defense firms, meaning, you don't want to be have you considered like not being a company that is just going to settle no matter what, at the very end is going to fold, or they settle early on, or whatever they give you in the beginning, they're going to offer you more at the end. Have you taken those things into consideration when developing your strategies as to how you're going to handle the claims?
Oh, absolutely, because you're right. And that's viewed from both ways. You're right. Plaintiffs' counsel, they're going to pick up on that and they talk amongst each other. So they understand their reputation. You're absolutely right. Don't worry about this company. They talk a mean game. They're never going to try a case. And so at some point in the courtroom steps, they're going to make you a bigger offer. But also on the other side, I look at it the same way too. This plaintiff's counsel has never tried a case. They don't want to try a case. They don't want to do any work. And so they're just talking a lot of stuff now, but eventually they're going to sell as well. So it does work both ways. But kind of getting back to your question, yes, I definitely take a look at that. And I try to make sure that we are not painting that picture where we're always caving in. Anytime I join a new company, one of the first things I look at is how many cases have we tried over the last 3 years?
Yeah.
And then I hear the numbers, well, we haven't tried any. And then I'm like, okay, well, they, when I say that plaintiff's counsel, they know that. The plaintiff's bar, they know you haven't tried any cases. And that's sending a message that you're afraid to try cases. And so you have to be cognizant of that as well.
Yeah. But there's also that flip side though, with trying of cases, because it really just does not happen as much anymore. I mean, even in like my career, I've seen it not happen as much anymore. Just I think on both sides, no one, plaintiffs' counsel included, like there's so much unpredictability in trying a case, and the time and expense that goes into it. It's sometimes not even worth it for them, because they don't want to. It is a rolling the dice, and they could get nothing out of it. So I've just seen a decrease on both sides. And like it's a lot of times I know as much as they do, like they don't want to do this. Like they don't want to spend the time doing this. Like it's, they have to do a lot of work.
Yeah, it's all posturing. I know you don't want to do this. I don't want to do this, but it's trying to get together and kind of reach a settlement here.
In fact, the judge doesn't want this to happen either, because it's a lot of work for them too.
Yeah, we actually at Kingston, we actually do every quarter. We actually have a mediation day. We actually have one this coming Thursday. So we try to bring in a bunch of cases and try to mediate those all on the same day. So that has worked extremely well for us. So to me, at the end of the day is as long as you kind of have your strategy, you're sticking with it, and you're having communication with the other party, that goes a long way. Don't sit back and wait for someone to make the first offer or demand. Just be aggressive, be proactive, and just pick up the phone and start talking to people. But you're right. I'm a person that took a $260 million verdict years ago.
Wow.
A case that you couldn't even do the math to even come close to the number. Eventually, we were able to sell it for $1 million. But that just shows the unpredictability of what the jury can do. There's no way on earth that you could take a person that's 20-something years old, single, no dependents, because the fatality, so it was a bad accident, but they died right at the scene. They made $30,000 a year. Like I said, they were 20-something years old, no dependents, anything else. The math never gets you to $260 million,
Never.
and I don't care what venue happens to say.
Never gets there.
Right. So, But the thing about that is, and I have to be cautious, is that if you do experience something like that, you don't let that impact the next case
Yeah.
that you manage. And I find that's a difficulty. Lots of times we'll read something, we'll see an article about a big verdict, and then all of a sudden that impacts you. And you say, well, now I'm nervous. I don't want to take the next case much further. And so there may be a tendency to oversell that next case. So be very cautious of that. So I was very cautious about the next few cases that I managed after that verdict, just to make sure that wasn't occurring.
Yeah. I remember like early on my career, the first case I got to try on my own, it was a Philly case and it was an arbitration appeal. And it was like a case I inherited from somebody else and I had to take it to trial and I didn't know what the heck I was doing. It was the first time I was doing it on my own. And it was like an appeal from a $12,000 arbitration award. So like should not have been a big case. And I remember I kept recommending, let's settle. And the adjuster just dug his heels in the sand and like didn't want to settle. And then I got a $300,000 verdict. And when I walked back to the office, to the partner's office, I was like, I am not going to have a job tomorrow. Like, I don't know but it wasn't really my fault. Like I remember the jury was out and I called the adjuster and left a message being like, they will settle for, I think it was like 18,000 like right now, and he like didn't call me back. And then the verdict came back and it was a terrible walk of shame for me. And after that I was scared. After I was like, well, that could happen again. But it was a learning experience for sure for all of us involved. But it's just so unpredictable.
It is, but you just kind of brought up a point with me. Like as a carrier, we understand we're the client, right? We're your client. But here's this, and now I use and that example you just gave, obviously the examiner dug, the heels in, and that's what they wanted. But I would say to the defense counsel, do not be afraid to really tell us what you feel.
Yes.
I had one counsel once, like, we may be in a room with other people and, he may tone it down a bit. But if he disagrees, I guarantee you, before I leave that building, he grabs me, takes me to a corner, and then really tells me what he thinks. Now, at the end of the day, it's still my call. But I need to really get that input from defense. Don't go along with it because I want to settle it. I'm digging my heels in. Call me out on it if I'm doing something that just doesn't make any sense. But I said, at the end of the day, it is going to be my call, but I do want that feedback and that honest feedback.
Yeah. And
I'm just speaking for myself. I will say, maybe not everyone can take that feedback or even want it, but I'm telling you, I want that feedback, and that's a partnership I want. To me, it's a true partnership. There's certain experiences and expertise that the defense counsel has that I don't have. And so I need to elicit that from you.
Well, and I think we all need to recognize too, we don't know everything too. And, I think as the attorneys, you need to honor your experience and your assessment and offer recommendations versus just being a yes person, because the yes person doesn't really get you anywhere. And in fact, it probably hurts everybody involved. And like, look, we all benefit from a counterpoint of view, right? Like the way I see a case, I could go to Josh and Josh could be like, hey, like, but what about this? And sometimes you just have that tunnel vision on, you only see it your way until someone offers a different point of view on it. And it's like, well, actually, I think you should be looking at this, or what about this? And then it helps, it makes everything, it gives you a broader evaluation, it more exact, and you can get better results, I think.
Right. And it's funny since you say that, because in my past, with a really complicated case, I have brought in people from the company that don't work in claims.
Mm-hmm.
Because, I could bring a group of, my litigation team or my liability team, there can be 6 of us in the room, and we can have different opinions, but it's all within a certain box because we all have certain biases. Yep. We're all still thinking with the insurance claims brains. We tend to look at things a certain way. I could bring someone in from accounting that all of a sudden looks at the case completely different. But guess what? It's not going to, if this case ever goes to trial, I'm not going to have a bunch of insurance claims people sitting there, right?
you're definitely not going to have one even.
Right, exactly. So why am I bouncing things off of you? Sometimes I like that other viewpoint because in my past, I've seen it where another person's come in and taken a completely different look at it. And also we're all sitting there going, oh, wow, we never even thought about that. And it does really help to bring in that different perspective.
Oh, for sure. I sometimes run things by like my brother, and I remember running a case by him, a year or so ago, and I explained the whole thing and said, wait. They already, I mean, they got money from, from their company for the injury. What do they need anything else for? I would give them nothing. And I was like, fair point. Because we just have this idea like, oh, but they're going to have to lien on the board. And then, and then we do like all our like claims math. And, but my brother was like, but they already got like X. So why do they need anything more? And I'm like, I guess, and like, and it's going to be people like him sitting there, like, deciding it all. But then of course you can't predict a jury. You just don't know what emotion is going to be on there. You too, like you could have one of him and 11 of another. So
Exactly.
how do you feel about, because we were talking a lot about like checking the boxes and things like that. How do you feel about younger attorneys working on files, like kind of like the learning curve involved? Like there's an importance there to having younger attorneys work on claims files so they get experience, so they can be experienced attorneys. But it does come at some sort of a cost though to carriers, because they a lot of times take more time, might spin their wheels. So I'm always curious to hear like what the carrier's viewpoint is on that like learning process that has to kind of happen on the attorney side.
Yeah, I take a practical approach to that. I mean, I understand it's going to happen. My sense is, let's just be fair to partnership. I shouldn't be paying for your learning curve or for your developing your staff. So I would take that in consideration. I would think that if you have a young attorney on a case, there's always a senior attorney overseeing. The bottom line is on the building part, if things are taking longer, I would hope that you would adjust that. It shouldn't take, if a seasoned attorney would have taken 4 hours to do something and this person is taking 7, then don't bill me for the 7 because now I'm paying for that learning curve. So just be conscious of that aspect of it. But honestly, the fact that it's a junior attorney overall, everything else other than the billing aspect, is not really a concern for me at all, because once again, I like different perspectives and they may see something that's different. Sometimes as an attorney that's been around for too long and that's not a benefit to us as well. They may remember how a certain venue was 30 years ago, which is great, but it has changed over the years. And so, so the other person coming in only has 5 years of experience, but 5 years with that venue. They know how that venue operates today. It didn't matter what happened 25 years ago because all that has changed. So there are some benefits to having the junior attorney. So for me, other than not having to pay for a learning curve, I'm 100% fine with it.
Yeah, it is definitely it's like this challenge, because you're like, like you got to learn somewhere. Like, I mean, Josh and I had to learn somewhere, like someone has to give you that opportunity, but there's, but
the opposite is true as well. Like I end up arguing more the opposite way. I'm usually saying, why do I have the senior partner on this basic claim billing me of this amount when you can have a much junior person? That's where I usually see the disconnect, is that way.
Yeah.
Like put a more junior person on this case is a really straightforward case.
But sometimes what I see too is like you had mentioned, like that's those very small claims. Sometimes you need a more seasoned person to handle the small claims to get it just done, versus like having someone who's younger and less experienced who might just like kind of like run through the motions. Because sometimes it just takes a more seasoned person. Like, this will be a 3-call case. I can make 3 calls, probably get this done very quickly without doing anything else. But a younger person might be like, oh, well, I got a trial in, municipal court. I have to prepare.
Well, that's interesting to say that, because as I mentioned earlier, we had created this early claims resolution team in claims to kind of get those smaller cases settled as quickly as possible. And the assumption is usually, well, that's where you put your most junior person. And I've always said exactly what you said. No, to really negotiate and to identify those cases and try to get it settled, you really have to understand claims. You really have to have strong negotiating skills to be able to recognize and get those cases settled before they speak to an attorney or to the neighbors or someone else. So there are really different skill sets. I've had people, I interviewed someone once and she said to me, she was working for a corporation and they also sold ice cream. And the claimant just loved their ice cream. She actually sold the case for $1,000 worth of gift certificates for the ice cream. And to me, that kind of creativity kind of comes along with an experienced person who recognizes this doesn't always have to be about dollars and cents. Sometimes you have to understand what that person's currency is. And once you understand their currency, then try to get the case settled.
Yeah, I mean, there's a certain nuance and understanding people. And it's kind of something you can totally learn. It's just some of it's experience, some of it's just personality, I think, and just getting how people work and that, knowing the currency of what's really going to get this to the finish line.
Yeah, I had a really tough case a few years back, and it was horrible. These two young boys, they were brothers, and they ended up dying in this horrific auto accident. And they were survived by a third brother. And so the tendency is, okay, this is a really bad case. You need to put all this money up on it. And I was like, I'm not sure how much money we can put. This family just lost their two sons. I think one was 13 and one was 14. But they had immigrated to this country a few years back. And so my whole thing is start telling a story about, instead of just going to dollars. Like, if you immigrated to this country, you came for the American dream. What's the American dream? It's education, it's home ownership, right? So start putting numbers towards that. Look, I can't bring your sons back, but the one that you have here, college education, paid for. When he comes out of college, right, he wants to buy a home, paid for. So those type of things are going to cost you a lot less than trying to write the $10 million check. You can just sell that story, sell that dream, and they'll start going, oh yeah, now they're putting value to the dollars, where 10 million means nothing, just more zeros. But all of a sudden they're thinking, all right, my son's education, we don't have to worry about that. Home ownership, all those type of things, and that's going to come at a lot less cost. That's how we have to start being more creative as opposed to just trying to write a check all the time.
Yeah, and sometimes people just want to be heard and felt, and I think sometimes we forget that the emotional aspect to a claim, again, we are in it all the time, so we're we just look at it very pragmatically, but then sometimes you have to remember on the plaintiffs, they are feeling this, or we put a value on oh, okay, well, they have radiating pain or whatever. I'm okay, but well, this person might have radiating pain every day, and this is emotional to them. Sometimes you have to detach yourself from it, but then also sometimes you have to attach yourself to it and be okay, put myself in their shoes. What will make them, what will make this softer for them? Maybe it's not dollars. It might be something else. So it's a little outside the box thinking.
Right, and sometimes too, it's just kind of the training that we've gotten as well. Years ago, I used to do a lot of medical malpractice cases, and I know that most of back then, I'm not sure if it's changed today, a lot of doctors were told you never apologize for anything, you never admit anything, and so that's the guidance that they were given, probably from their general counsel or something. You just never admit anything, you don't apologize. But sometimes, to be honest, and to your point, all the person kind of wants is an apology or somebody acknowledging something, and then it kind of go away. But I can see from a legal perspective sometimes why you give that kind of guidance to never do that. But it's one of those things, you have to be there and be able to make that call yourself. I could be able to size that person up and say, look, I just really think they just want to be heard and they just want me to acknowledge something here, and that's.
Well, and that comes into huge play at mediations. When you don't necessarily need your insured at a mediation, but sometimes having the insured to be there and say, like, I'm sorry this is happening, or even if it's the claims professional there as well, but I'm sorry this happened to you, and you're not admitting fault, but you're saying, I'm sorry. And that could go so far with that plaintiff, just to feel like, oh, I they hear me, and they feel like they understand what I'm going through, and they're not out here just to attack me or, not to give me money. They, we're just trying to come up with the number that makes the most sense.
Correct.
Well, we're just about out of time. I know you have something coming up after this, so I don't want to take too much time, but I don't want to let you go before I ask you this. Knowing what you know now, going through, all that you've done in your career and being where you are now, what advice would you give your younger self?
Wow, that's a really good question.
I like to end it with this thinker question.
Right. I would say this, obviously, as I said at the beginning, how we started, this was not a planned choice for me. I kind of fell into this, and I'm really happy because it's really given me the ability to have all the experiences I've had living in a different country. I've done a lot of traveling, things I wouldn't have done had it not been for this industry. But if I had to kind of go back, well, it's kind of hard because if I go back now, I kind of know what the future lies. So my career track might be a little different because I do counsel a lot of young folks coming into the industry. I sit on an advisory board for Verizon Insurance Star Executives, and you have to be 35 years of age or younger to be part of that. I just sit on the board. And some of the counsel I'm saying, to them, the advice I give to them, I guess is the same thing I would give to myself. That the industry is really about data. And when we're younger, we never even think about it. We didn't start thinking about data until recently. But that's what it really is. In the past, we thought it was more about, okay, all the data I need is in my head, right? So I use my memory, I use my judgment, and then implicitly my bias comes on. That's how I make decisions, right? It's my memory, my judgment, my bias. But it's really about getting data. And when I started, obviously there was no computer, I couldn't Google things. But I think the thing I would have done more was get a lot more information from other people.
Yeah.
I did some of that, I'm glad I did, but I've done it a lot more. That, if you're sitting there at 20-something years old, I want to be on this fast track. I'm thinking about these things I want to do. And I want to be strategic. I should be spending a lot of time with a person that's been doing it for 30-something years, longer than I've been on the earth at that time, and really picking their brains before they exit out of the industry. Because that's kind of like what happened. By the time I figured it out, a lot of the really seasoned people had long retired and were gone. And so all that knowledge walked out the door and kind of left my industry. I would have tapped into that a lot more if I knew that.
I think that is really good advice, because that's something I'm thinking of myself. I'm it just asking more questions and being more of a sponge.
Right.
And I do feel, at least for myself at that time, I was always very concerned about taking too much time away from the more experience, because I'm they're so busy, they're so important, they have all this stuff going on, I don't want to bother them. And if you have to kind of let go of that and be well, but I they're here, they could help me. I don't want to take the time away, but also it's a benefit to them too to have me learn from them. So it's hard though, I think, when you're younger too, because you don't want to be a nuisance either. At least I would always I don't want to bother them.
Exactly. And I'll add one point to that, because I do that now. I've done much later. Going back, I would have created my circle of excellence a lot sooner. If you leave a company, don't leave the people behind. If you know someone that's really good in coverage at your last company, or someone's really good in, auto PD, keep those connections with you and always use that as your resource as you move through your career.
Yeah, that is very good advice. Also advice I would have given myself, my younger self. Well, Nigel, I appreciate you taking the time to join us today. I appreciate when anyone takes the time away from their busy schedules to join us on the podcast, and everything that we've talked about today. you've offered so much knowledge and insight into, how you look at claims and the metrics and, and just your experience. So I really appreciate you sharing it all with us. So thank you so much for joining us today.
Absolutely my pleasure. Thanks for having me.
Thank you, Nigel.
And then for all our listeners out there, of course, if you like what you hear, please like and subscribe to The Defense Never Rests. We are on Apple Podcasts. We are also, you can find us on YouTube at TDNR Podcast. And, please subscribe and stay tuned.